I want to say welcome, ladies and gentlemen, to the Tony Hollis Live Talk Show Testify. Again, this is a special broadcast coming to you where we will be talking about a very important topic today. It's a learning session, if you will. We're going to be talking about prosecutorial misconduct. I do have an attorney as my guest today, so please just sit tight, and we will get this show started just real shortly, okay? And I want to say, while you have the time, I would like for you to tell somebody to please join in and do hear this very educational broadcast that we will be coming to you today. Okay? Prosecutorial misconduct. You don't want to miss it. I want to say welcome, ladies and gentlemen. Tony Hollis Live Talk Show Testify. Special broadcast, as I indicated a few days ago. We will be talking about prosecutorial misconduct on today. I do have a special guest, a local attorney who will sit and pretty much explain to us, exactly what is prosecutorial conduct and the things that's attached to it. Okay, but before I bring my guests on, I just want to say my condolences go out to a young man that I know here in Blavel. He was involved in an accident yesterday. As a matter of fact, I didn't witness the accident, but I did see all of the debris, the cars that was upside down, one in a ditch that was engulfed in fire, and I knew then that it looked very bad. And but yet and still, I was hoping that no one was hurt, um, at least deceased. But unfortunately, we did lose a young man from Blavel. I had the privilege of training him on the job, a job that I did work. A very respectable young man, listen, good kid, real good kid. Um, and so my condolences go out to his mom. I know his mom, I know his dad. They're good people. And so let's keep the family in our prayers uh, as the family, is in the midst of this grievance period. And so please do keep them in your prayers. Also, I'm yet getting, questions or what have you, or those who may want to restart the NAACP back up. Many of you know how I feel about that. I had a discussion just today on the NAACP. Um, and so if you all really want and serious about starting the NAACP up, I mean, I will help you, but I do not want any parts, no titles, no. I just don't want to have any part of it. I had a bad experience, not with the people in the community, but that's another story. I think many of you know what I went through. But anyway, the only thing about the NAACP is that really grieved my heart is we had a college fund for our young people who was coming out of the high school. And that fund was used uh, to give them the opportunity to use that money, uh, to pay for their, books or, travels or just going toward their, their scholarship tuition. But anyway, unfortunately, when I left, the fund was depleted. We had about right at about $5,000, a little better, in that fund, and I just think it's just very shameful that here we are, another year, and the NAACP have no scholarship funding uh, to give out. Uh, I want to say to Miss Doggins, that was her husband, Mr. Booker T. Doggins, uh, who left that with her. And those was his wishes, his desire to keep that college fund going. Unfortunately, we have had some people locally that have really trashed the desires, the memories, the will of a man that who gave so much to this community. Speaking of Mr. Booker T. Doggins, his wife, Mrs. Ann Doggins, she was the one that overseed that funding. But unfortunately, they just took the money and did whatever they did with it. And so my heart go out to her. But anyway, we're going to get to the topic at hand. We're talking about prosecutorial misconduct. Many of you saw the video that I did today, the ad that I did. For many of you who didn't see it, uh, uh, let me just go ahead and run it for you. But this is the ad of Miss Aarika Thompson. She's a very, very superior attorney. She have made a list of attorneys, 40 out of 40. 40 out of 40. Out of 40 attorneys that's 40 years or younger, she have made it for 3 years straight. So I think she deserved that recognition. And so many of you, when you see her, give her a pat on the back, and congratulate her. All right. But let's run that ad that I ran today if you didn't see it, okay? So let's run that now. Okay. Now I'm hoping that it's talking. Anyway, got some volume. Turn this down. Actually, what that is, I thought that was the video, but let's go over here and run it. We got it over here. Okay, and for those of you who didn't see this award, this is a very prestigious award. Like I say, Attorney Thompson, she have received this award out of a list of attorneys here in Arkansas, um, the top 40 under 40, top 40 attorneys under 40 years of age. She have received this prestigious award for 3 years straight, as a civil plaintiff and also criminal defense attorney. And so when you see her, give her a prompts, okay? For those of you who don't know. And so we just wanted to put that out there and just to let you know that we do have uh, an attorney, a law firm, one of the several law firms that we have here in Blythe that is more than willing to service you. Okay? And so please do get by to see her. So without any further ado, we done got all the preliminaries out of the way. Let me bring on my guest and let her go ahead and speak to you on the topic at hand today. And without any further ado, let me bring on attorney Aarika Kilgore Thompson. I hope I pronounced your name correctly.
It's Aarika, actually. I should have told you that
All
already.
right. Oh, that's easy. I know that's
Yeah.
easy. Yeah. But yeah, I just wanted them to know, not that you need, uh, to be qualified for this show, but I just wanted to go ahead and let them know the very superior record that you have. What was that? Three years straight you won that award, correct?
Yes, thank you for that.
Yeah, 3 years straight. And so, uh, as we say in slang terms, you go, girl. All
I
right,
appreciate that.
all right. But what we're going to be talking about today, we're going to be talking about prosecutorial misconduct, and I'm pretty sure that you're very familiar with that term. And we do want to say, my guest and I, this show is for educational purposes, and so this show is not about us coming on trying to attack any local attorneys, local prosecutors, that is, but we just want to go ahead and inform the public. This is uh, an educational broadcast for those who have not even heard of the word of prosecutorial misconduct. Okay, and so before we get into the show, I want to turn it over to my guest and let her further go ahead and tell us a little bit about herself, her background. I think she served as a prosecutor as well. I'm pretty sure she'll touch base on that. So let's go ahead and allow Attorney Thompson to go ahead and speak to you about what drove her to Blavel, why she chose Blavel, and since she been here, how she like it. But anyway, she live in Jonesboro. She just got a law firm here. But anyway, Attorney Thompson, I turn it over to you. Welcome to Testify.
Well, thank you for having me. I appreciate the opportunity to come on your show.
No
I'm a fan of your show. We watch it quite a bit.
All right, all right.
To stay informed.
Right.
I think you already said this, but I have a practice in Blythe with Jacob Holmes, Thompson and Holmes. We just opened a location in Jonesboro, so we have 2 offices now. Our areas of practice, we do lots of kinds of law, divorces, civil cases, personal injury. But one of the biggest areas that we practice is focused in criminal law. My first job as a lawyer, I was a deputy prosecutor. I prosecuted drug cases and then went on to, I was focused mostly in Poinsett County and did all kinds of cases. And then I forgot to tell you this earlier, but I also did conflict cases for the whole circuit. So I think I've prosecuted a case in every county
All right.
in our circuit. But did that for a few years. And then I went to work for Jim Harris, who is here in Blythe. That's how I ended up in Blythe.
All right.
And I worked for Jim for about almost 2 years until he passed away. And then, wrapped up or tried to wrap up his practice. And then we opened our firm. So,
All right.
and so that's how I'm here. And I love being in Blythe. made the conscious decision to open our firm here. And I love the people here. I just really enjoy it.
Well, it's always heartfelt when we can get people to locate here in Blavel and have good things to say about Blavel. Just make us happy. We take pride in our town, and that's why I'm probably one of the critics. One of the critics. I don't think I'm the only critic, but I'm one of the critics that not so much talk down Blavel, but when you see something that needs some attention, if you will, then I think it's only right that we call it out, and hopefully, it'll be resolved. And so, but anyway, we want to go to, and I want to say again to the audience, we will be taking a break every now and then. I go over to my board, and if I see any questions, I have to leave that up to Attorney Thompson, if she desired to go into asking any kind of questions. She pretty much like myself. Some cases walk a fine line because we don't know exactly what cases are out there now that her law firm may, be involved in as we speak. And so if she refused to address a particular question, it's not like she just, um, ignoring you, but there's a reason behind that. So hopefully you'll keep that in mind. But we're going to talk about, let me find my banner over here, some things that the main four types, if you will, of prosecutorial misconduct. That's basically what we're going to run through right now. The four types of prosecutory misconduct. Okay, and they are. I'm just going to show them to you. We'll come back and start over. The very first one we're going to talk about is failure to disclose exculpatory evidence, and of course, number two, introducing false evidence, and number three, using improper arguments, and last one, which is discriminating in jury selection. All right. So for those that might be wondering, what are you talking about, Tony, when you're talking about exculpatory? Uh, excuse me, when you're talking about prosecutory misconduct, and uh, and I'm going to let my guest explain that, but just to give you a snapshot, when we start talking about prosecutory misconduct, basically, you'll find that word come into play, exculpatory evidence. The exculpatory evidence is favorable to the defendant in a criminal trial that exonerate or tends to exonerate the defendant uh, guilt, uh, defendant of guilt, excuse me. And so that's what that is. And the other uh, thing that we're going to talk about that actually run in this same circle, many of you might have heard, or some of you might have heard, what is called the Brady Rule. That's where the prosecutor have a duty to disclose exculpatory evidence. And I'm pretty sure the attorney will give you, my guess that is, will give you probably an example of both in terms of, when it occurs. And so I'm going to turn it back over to my guest and just let her start. I mean, let's talk about this very first one up here to what we're talking about, failure to disclose exculpatory evidence. I mean, Attorney Thompson, what are we really talking about here?
Well, I think that the definition of prosecutorial misconduct, just overall, is when a prosecutor either illegally acts or fails to act purposefully and intentionally to try to convince a jury or a court to wrongfully convict a defendant or to impose a harsher sentence than what's appropriate. And I think that and failure to disclose exculpatory evidence is a big type of that definition. And there was a study that I read about the National Registry of Exonerations did a report in September 2020. They looked at 2,400 cases where innocent people were exonerated between 1989 and 2019, and 30% of those people, their cases were affected and they were ultimately convicted due to.
Let me stop you again. I want you to repeat that. You say 2,400?
Yeah, they looked at 2,400 cases where innocent people have been exonerated from 1989 until 2019. And 30% of those cases, it was found to be due to prosecutorial misconduct. So it is, something we need to be talking about.
So in other words, almost half of those cases that was found to be prosecutorial misconduct. In other words, these people, 30% of those cases to where the prosecutor was getting ready to prosecute them for whatever reason, those people turn out to be innocent.
That's right. They got overturned because of that.
Overturned. Also got overturned in the court of law.
That's right.
All right. Oh, wow. That's almost half, 30%. And so thank you for that opening on that short introduction, or should I say the meaning of exactly what is number one in terms of different type. I mean, the four main types of prosecutorial misconduct, and the other one, if you will, introducing false evidence. I'm pretty sure that's pretty much self-explanatory, but I'd like for you to go ahead and just share with the audience number two.
I mean, if you read about it, there's several different types of false evidence. I mean, we've heard about the cases recently, in other states where officers had planted, evidence or lied about a crime even being committed. So that would be, false evidence. But also introducing false confessions would be introducing false evidence, especially if they're aware that those confessions were elicited by means of coercion or something like that. If somebody had a real low mental IQ or had mental illness, for example, they may falsely confess. And so the prosecutor has a duty to not put on false evidence.
Okay. And if the guests have any type of questions about these four main types of prosecutorial misconduct, we'll come back later, but we just want to run through the four main types and then we'll just backtrack if that's okay. And number three is using improper arguments. Can you sort of explain that to the audience? When a prosecutor does this, I mean, exactly what words are being used or what have you?
I made a list of some examples because, we have rules. That's the whole big premise of law is we have rules we have to follow. And some of the things they cannot say to a jury to try to improperly sway them. So let me find my list. Sorry. If they make personal attacks on the defendant or defense counsel, for example, there's been a case that was overturned because the prosecutor tried to appeal to improper considerations, is what the court said. The prosecutor can't say, well, what we call the golden rule. You can't say, well, put yourself in this person's position because you're supposed to be impartial. You can't appeal to them as parents or things like that. There's been a case about that. You can't comment. A prosecutor cannot comment. This is a big one on the defendant's choice to assert their Fifth Amendment right to remain silent. If they did that to a jury, that is improper. They can't refer to matters that are not in evidence or on the record. And they can't step outside their professional role. For example, they can't talk about their personal views, their personal opinions. They have to stay within their role in front of a jury. And they also cannot misstate what the law is and mislead the jury. Those are some examples.
And correct me if I'm wrong, but if a person have a criminal record, Is that fair play for the prosecutor?
Typically, no, not during guilt. We call it bifurcated trials, which means that the first stage of trial is just for the jury to decide if they're guilty or innocent, and then if a jury found them guilty, then you go to sentencing, which is the second stage, is separate. In sentencing, the prosecutor can bring up prior crimes, but typically not during guilt. There are a few exceptions. For example, if you're being charged with, we call it felon in possession of a firearm, but I think it's possession of a firearm by certain persons is the actual legal term, because the prosecutors have to prove you've committed a crime before, right? For example, so that would be one exception, but typically no.
Okay. And of course, the very last one, which I'm pretty sure many that may have been in trouble can relate to this fourth one, discriminating in jury selections. Kind of touch base on that, please.
Well, I mean, you can't. Okay, let me back up. So when we were picking a jury, each side, defense and prosecution, gets so many strikes, and that depends on the charge and things like that. But they get to strike certain jurors. And that you get so many strikes, I should say, just because you want to. But you can't use those to discriminate against jurors based on gender, race, and other classes like that. And so if a defense lawyer thinks that a prosecutor's doing that, we make what's called a Batson challenge, which is based on the case Batson.
Okay, repeat that term again.
We call it a Batson challenge.
Okay.
Which is basically the prosecutor has to explain. So hypothetically, and I've never done this, I haven't had to do this, so this is not aimed at anybody, but hypothetically, if I saw that the prosecutor I thought was, striking every juror that was an African American, I could stand up and make that challenge, and then they would have to explain to the court why they did it, that it wasn't based on race, for example.
Okay. And so, do the judge have a duty to? I mean, I know if you're representing a client, of course, you have a duty, but also should the judge? I mean, he's presiding or she's presiding over the proceedings there. I mean, wouldn't there be some expectation for them to say something as well?
Yes, and I'm on my list when later on when we talk about what could be done to hold people accountable.
Okay.
I talk about how the judges have a duty to do that.
Okay, then, fair enough. And of course, and that's what brings us back to where we want to get into talking about exculpatory evidence. And I'm pretty sure you have a list too. And so if you want to deviate, and if there's something that you feel I haven't covered yet, please feel free to jump in and share that information. Okay.
Okay.
All right. So, but let's just go ahead and go back to exculpatory evidence. I think we established exactly what that was. And there's another word also called, is it incorporatory or something like that, evidence, to where that is more favorable for the prosecutor. But in this particular case, we're talking about exculpatory evidence, which is favorable to the defendant.
Right.
And so, first of all, let me ask you, who controls all this evidence? Let's talk about that. Who controls all the evidence?
Well,
who's in possession? If you got a murder trial, of course, I'm pretty sure the detectives, the police department or whatever, they done did their job, and whatever evidence that they come up with or that they take in, I imagine all of that is given to the prosecutor, correct?
It's supposed to be. I mean, it is supposed to be. Yes.
Okay.
And the crime lab, and any other state agency, that works on it.
So does the prosecutor, does he get to pick and choose what evidence? I mean, if he's getting ready to prosecute someone for murder, for rape, or whatever, I mean, we do know that he must disclose certain information to the defendant,
Mhm.
but how can one be certain that the prosecutor has information in his possession that may be favorable to the defendant? Um, how does one actually, find out about information like that? I mean, what is the process of seeing if the prosecutor is holding out?
It sounds on paper, it sounds like, it would be kind of fairly easy to go through, but in fact, in reality, it's not. Um, for example, I can't remember the defendant's name who was exonerated, who, had been sentenced to death and was let out because the prosecutors in that case tried to use as evidence that these people, that he allegedly killed a woman, and they tried to say that they were complete strangers,
Mhm.
and that was used as evidence against the defendant. And in fact, the defendant had been in a relationship with this woman, and so that's why he had been around her, was the real reason. And the prosecutor had witness statements saying that, and phone records showing that, and they completely withheld that, for example.
Okay.
And so I don't remember in that case how the defendant ultimately found that. Yes, I do. I remember that a detective that had worked the case just so happened to keep, I guess, a case file in his garage, and he went through it and found those and turned him over because the guy was on death row. And so that just so happened the detective turned him over, and then that led to his exoneration ultimately.
That is very scary. If, as a matter of fact, I also did some investigation as well as like yourself, and I read where there was even a high percentage of those people who was I guess, a victim to prosecutorial misconduct. There was a high percentage of those people that was facing the death penalty.
That's
I
right.
mean,
Hmm.
that is really, that is just, it just blow your mind to know that we have or at least we're supposed to have a justice system that should be concerned with justice as opposed to just winning cases. But we
Hmm.
do know that we have some. Is it fair to say that there are prosecutors out there, probably as well as judges, who may be ambitious for whatever reason, or could be to use whatever position, like the prosecutor position, to is a stepping stone to maybe land a position on the high court.
I mean,
And
sure,
so,
that, yeah, and a lot of attorneys are ambitious. I mean, and I'm not saying that all people that are ambitious, would act with misconduct, but
mhm,
rather I think that our whole culture and media um, praises prosecutors, who are tough on crime, who have high conviction rates, who have harsh punishments. And in some cases, that might be warranted. But when you have a society that, um, that's the only goal sometimes, especially when you read news stories,
mhm.
it lends to a potential cause, you know, to make someone want to act with misconduct. And
Okay.
that's something that needs to be changed, I think.
All right, fair enough. Um, Again, um, let me ask you this here before we go on. Uh, would it be fair to say that a lot of these cases, who fall prey to the prosecutors in terms of, them being I guess I keep using the word victim. Uh, would it be fair to say that a great majority of these people are from the low to the very low economic status?
I mean, I think that's true about if you look across anybody even charged with a crime. I'm not saying that rich people are never charged, but um, typically, if you look at the statistics, um, impoverished people are more likely to be charged.
Okay, because they don't have the necessary uh, money to hire top quality attorneys that probably have are very linked to resources to help clear their client, which the public defender have limited resources and probably overwork, high caseload or what have you. Uh, but anyway, and so uh, moving through, is there anything else you want to expound upon exculpatory evidence before we move to the Brady rule?
No, I do want to say though that, I mean, we do have, I know all the public defenders in this county. I mean, yes, public defenders have a lot of cases, and that's true. It's difficult to have the time to really sit down and look at a case, you know, as soon as you get it and really work it. But I do think that from the ones I know, do a really good job. I've seen them, you know, make really great arguments for their clients, and I'm glad we have them here to do that. I think they do a great public service, especially for what they get paid. They do a great job.
Okay. I agree, you know, with the limited resources that they have, and, you know,
Right.
they're not actually, you know, paid a whole lot of money. Another thing. And so tip my hat to them for, you know, making it work with, you know, the limited resources that they have. But let's move on to the Brady rule. The Brady rule. I think you and I have talked about this, how this rule came into play. I think it was a case, Brady versus Maryland, to, I guess, how this particular rule came into play. And what this rule actually says is the prosecutor have a duty to disclose exculpatory evidence. And so just for the audience to get an understanding, let's just say, for example, you get a person who has been charged with, say, rape, but he has an alibi that there was no way that he could have committed the rape because he was at an event with a group of people. And the prosecutor is late coming into finding out that to be true, the fact, but nevertheless, he chooses to not disclose the information. Would that fall somewhere in this category where we're talking about the Brady rule?
Yeah, especially if
Or
there
let
was
me
like
give you, let me just allow you to give your examples.
No, I mean, if there was, like, if that was the case and there was video, or, you know, like if there was like a sky cop nearby, or any sort of proof that he wasn't, you know, at the area that he was alleged to have been at to commit this crime, yes, that would be exculpatory. That's a good example. Trying to think of some other examples. Of course, you know, if they found DNA and didn't run it, or if they found DNA and ran it and knew that that would, you know, potentially exonerate a defendant, that would be exculpatory evidence. If they have evidence that maybe somebody else did it, you know, another thing is exculpatory evidence would be, they are supposed to give us all, and they do here, they give their witnesses criminal history and bad things in relation to anything I could use to impeach a witness. That's exculpatory as well.
Okay. And now I'm going to go ahead, before we go to the audience, I'm going to go ahead and give you the opportunity to, you know, because like I said, there's some things you in the office every day, you know, you in court, you know, a whole tons of hours. And so let me just extend the floor to you for you to go ahead and just, you know, cover anything that I might not have shared or asked of you. And so let me extend this opportunity for you to go ahead and share a little bit more about, you know, I think you took some notes and some things that you want to share as well. So I extend that time to you now.
Okay, well, yeah, we talked a little bit already about the National Registry of Exonerations report. And so I want to talk to you about some of the statistics that report showed, because it took them like 6 years to put this report together. So it's quoted quite a bit because they did such a good job with it. That report showed actually that of all the people that were exonerated, so they'd been found guilty and then eventually, you know, found to be actually innocent, wrongly convicted, 54% of those cases were due to government misconduct. So over half were government misconduct, but 30 was prosecutors. So the other percentage would have been law enforcement, things like that. Anybody that's with the government. So that's a huge number, and I think that really is something that we need to think about. And they looked at who is mostly affected based on those cases. And they found that Black defendants, African American defendants, are slightly more likely to be victims of official misconduct. They found it was 57% in cases of African Americans versus 52% in cases with a white defendant. And so, and they also found that the more serious the crime that you're charged with, the more likely it is that misconduct occurs. And I don't know that this shows that this happens all the time and is so common in every case, but it does show that it does happen enough where we need to be talking about it, and it's a problem. And we need to have some parameters that can kind of help be some safety stops to help prevent some of this. So,
well, there was the other thing that I had to ask you. Of course, you might want to close on it. I don't know, but we talk about, and we do know that prosecutorial misconduct, it does happen. So, what are some things that can be done? Well, first of all, whenever it is proven that there has been prosecutorial misconduct, what are some things that the judge can do?
Well, I guess while it's happening, a judge has a duty to kind of call the shots and maintain the courtroom. And so, of course, they should, keep an eye out for it. And of course, if they see it, they can and should, sanction or hold a prosecutor in contempt. They can do that. And I think if they did do that, that would deter some of this from going on. And I also want to talk about, I don't know, I assume it's every state, but definitely in our state, our prosecutors are elected. And so voting, I think, is very important in deterring prosecutorial misconduct, because the head prosecutor has the power to reduce misconduct. They an open file policy, which allows, and most prosecutors here in our district do have that I'm aware of, where I could go to their office and say, hey, I want to see your file. And I can just look at everything they have. And the head prosecutor can set real clear rules and procedures and discipline those deputies that don't follow those and violate that. And so voting for, an effective prosecutor is important for that. And, they also have the power. We don't have this here, but they've done this in other states. Prosecutors have the power to create a review unit. They call them conviction review unit or conviction integrity unit, which is a group within their own office that if there's a complaint filed, they go look and make sure there was no misconduct on the part of their office. And that has been shown to deter some of this behavior. So,
okay, what do you call it now?
They call it either conviction review unit or conviction integrity unit. So I think just even knowing that unit is available and there is beneficial,
Kind of like having a watchdog type.
That's right.
Group, Oh, sound good. I didn't know such process was available. I just thought that they were just free to do whatever, but I know the time is getting near, and I'm gonna let you close out and any other thing that you might want to say that you hadn't said. But I want to show you. I don't know if we have a look like we have a question here. We got what if the judge is a part of, I guess, the misconduct? I mean, you ever ran into any type of cases over the years to where a judge might have been somewhat in collusion, if you will, with whether it's for the defense or the plaintiff? What can be done if a judge, uh, I don't know how you prove it, high bar that is, but let's just talk hypothetical. What if it is proven that the judge is somewhat involved in whatever the wrong that is being done?
Well, I didn't look into cases about that, but because we call that judicial misconduct, right?
Yeah.
So that's separate, but it is. I mean, it is a thing. We're all human, and when we're dealing with human nature, there's always room for misconduct, right?
Mm-hmm.
I think you'd agree with that. And so,
Oh.
I'm sure there are cases of judicial misconduct. I have not been involved with one, not that I'm aware of. And so I think we have some good judges, and they've done a good job. But yeah, I mean, that could happen. They're not supposed to communicate with like one side, for example, without, there's some exceptions under the rules, for emergencies and things, but they're not supposed to communicate like with the prosecutors without me knowing. That's called ex parte. That could be misconduct. Mm-hmm. So things like that. Yeah, I mean, yes, that would be a big deal. And I guess it's kind of the same with the prosecutor misconduct, that if it got proven, I mean, they could be disciplined by the judicial committee, just like an attorney could be disciplined by the licensing committee.
And that's pretty much going through, I guess, the Arkansas Board of Professional Conduct.
Right.
Yeah. Okay.
Mm-hmm.
And they have a process for judges and attorneys, correct?
That's correct. And our rules, our professional rules of conduct, we have a rule included specifically about prosecutor conduct, Rule 3.8. And 3.8. So that allows for prosecutors, if there was misconduct, it would allow for an avenue for somebody to make a complaint to the board or to the bar about it.
Okay. See if we have another question over here. Mississippi County don't have a chance until we get them out of office, point blank. I think you pretty much alluded to that the prosecutor position, especially we got one going on right now, a district prosecutor, to where I think is, I can't pronounce her name. I just call her Attorney Sonia. She's cool with that. She allowed me to just use her first name. But Attorney Sonia and I think Liddy is the two candidates that will, I think they come up with November.
I think you're right. Mm-hmm.
And so they will be opposing each other. And so those that are looking, I'm hoping you're learning exactly something from the role of the prosecutors and their duties. And hopefully this will somewhat, give them some type of insight on how they should cast their vote. And so, so yes, we do have a judicial process, going through the Arkansas. Is that Arkansas Bar Association that have the Board of Professional Conduct? That's something like upon the umbrella of the Bar Association.
No, our Bar Association's optional to be a member of. It's just the Office of Professional Conduct. It's their own office. If you Google it, you can find it. And I mean, if anybody needed to make a complaint, they can do that.
Okay. See if we have another question up here. I'm gonna try to run through them as quick as we can. What's that? It's just what Miss Jackson said. Okay. I think she just commented on it. This is Miss Oliver, but everybody know what's going on, but scared. She's just making a statement. If a murder case, in a murder case, shouldn't the prosecutor have the evidence, even if they're saying it might be justified? Are you understanding the question?
I think I understand the question, which is that if law enforcement is indicating that they believe a someone's death would have been justified, that they should still turn it over to the prosecutor to look at. I think that's what she's saying. And I'm trying to think of how to tie this to prosecutorial misconduct. I think that if they're looking at charging anyone, like that they should, yes, law enforcement should turn over everything to the prosecutor for them to look at, and they don't get to piecemeal it to try to make somebody look more guilty, or, they have to turn over the entire file. They have to do that.
And let me interject for a minute. We had some strange things going on in Blavel, this year, 22. Correct me if I'm wrong. Who job is it to bring a charge?
That's the prosecutors do that.
The prosecutors.
Mm-hmm.
Okay, well, let me ask you this here. What if the police department make that call to where, let's just say, there's a shooting. Let's just say that there's a shooting, and the police just pretty much, I guess, based on whatever evidence that they conducted, because someone has a loved one that's, won't be coming home. Shouldn't whatever evidence that is confiscated or whatever, shouldn't that evidence be given to the prosecutor, and the prosecutor make the decision to charge a person? Or can the police department do that? I mean, I'm not trying to put you on the spot.
Well, I don't know, because I mean, I have to think about it, because, for example, the police, they investigate all kinds of things, just little petty crimes that don't turn out to be true, right? Or at least they don't have the evidence of it. Okay. And so they don't turn over everything to the prosecutor if it's not going to be, if it's just blatantly not a crime. Wouldn't
that be a violation of the Brady rule, though, if they don't turn it over? I mean, especially if it's considered to be exculpatory evidence that will favor, say, the defendant. I mean, wouldn't that be a violation of the Brady rule?
No, I'm talking about if there's no defendant. If they don't charge anybody, then it's not exculpatory.
Okay, no defendant.
Yeah, and so in those kinds of cases, but when we're talking about death, the death of someone, a loved one, typically the prosecutor is aware of that, and they do request that file. And then at that point, yes, everything should be turned over to them.
So actually, the prosecutor since he or she is going to be the one to prosecute the case, they should actually be more concerned as to whatever evidence that might be available before they take this case to trial, hoping for a conviction. And so if I'm, say, a detective or a police chief or whatever, and you're the prosecutor, and I'm saying to you, it's nothing there. We checked it out, blah, 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 and it's a justified shooting. Let's just use that. It's a justified shooting. Shouldn't the prosecutor be equally concerned about looking at the evidence to support the decision that, say, like the detective or police department had made? I mean, shouldn't they want to see what evidence that is available for them to, to make that call? I mean, shouldn't it be, should it be the duty of the prosecutor to do that?
I don't know if it should be, and I don't know if it is, but I also know that we're talking about something that's going on right now, and I'm going to be careful about what
I understand. And that's what I say. If there's anything that pretty much going to cross the line and you're involved in a case, whatever, then we'll leave that alone. So we'll just close on that then. But
I don't want to get I don't want to get myself or anybody else in trouble.
Yeah, I understand. And we definitely, especially if you got clients, we definitely want to try to say anything that may somewhat hinder their upcoming trial. Uh, but anyway, look like we're almost at the bottom here anyway. I think everybody else pretty much just speaking. Uh, so let me see. I don't know if this is a statement or what. It says so they uh, doesn't supposed to communicate with the officers that's over the case, or they can talk to them.
Yeah, they can talk to them, and
Talk with them.
they do talk to them. And but also the defense lawyer is entitled to talk to them. Also, I've run into some instances sometimes where officers say, "I'm not going to talk to you without my attorney here," and I'm like, "The prosecutor doesn't represent you; they're not your attorney." And I'm entitled to talk to you, and so it goes both ways. But yeah, the prosecutor does and does talk to the officers, because a lot of times they get the reports and it's not real clear, and so they get to they have to ask them kind of what's going on, or to clarify, or to get more evidence or things like that.
Okay. Well, we're getting down to the bottom of the hour now. We got less than 2 minutes, and so if I don't see any question in here, I'm gonna give you the opportunity to go ahead and close out. With the broadcast. I think most of these here are basically just statements and what have you. I'm going. Uh, this is Miss Jackson. She says she going through this right now. I guess you're referring to I guess the topic that we're discussing. Uh, it's what is it? It's just saying get out and vote in November, unless we indicated. You want to try to bring in good prosecutors. Then you don't like what you have, get out and vote. Uh, and so, good question. What is that? Or is it enough evidence? I think that was a previous question that you had a pen. I mean, you answered. Uh, Everything in a report should be turned in.
I agree, and everything that they know about that's not in the report should also be turned in. One big problem that I learned from practice is, like, for example, if you request reports from the crime lab, they give you like a very, and this if the prosecutors request a report, they give them a very short version of what the report is. They don't give them everything that they did, when they received everything they looked at, and you need that long report. So if the prosecutor requests, hey, give me what you have, and the crime lab just gives them a 7-page document instead of a 47-page document, that's a problem.
Mhm.
And that happens, and the prosecutors have to know, or somebody has to know, the defense lawyer, if you don't get it all, if it's short, that's probably not all of it, and you've got to go request the long file, for example. That's one thing that just needs take some education, I think, to make sure that everybody turns over everything they're supposed to turn over.
All right then. Fair enough. And I guess it's just because what someone don't see, someone else might see it, uh, which is true.
Mm-hmm.
She's trying. What's that? She's trying to help. Thank you. Or trying to help you. Thank you. Uh, yes. Thanks, Mr. Hollis. You are appreciated more than all. She's just giving me a little love. Well, thank you, Mrs. Barclay. Uh, let's see, me neither. And I think we down. That's the last of it. And I do want to say, I thank you for taking time out of your busy schedule. I know you and your partners have your hands full. Uh, but I did want to. There was one other question that I wanted to ask you, uh, which was, uh, say if you had a client that you was representing, just this hypothetical, um, and you believe that there need to be some when you call for an internal investigation, as opposed to, I never liked it to say the local police department. I never trust the local police investigating the police. And so if there's an attorney who don't trust the police investigating the police, I mean, what other alternatives or options would that attorney have? You know, I mean, could he request that a special prosecutor be assigned to investigate the case, as opposed to having the police investigate the police?
Well, if I had a case where I thought there was police misconduct, they normally have the state police investigate law enforcement agencies. So but I don't have power to ask the state police that. What I would do is go to the prosecutor and hope that we have a professional enough relationship that if I said, look, I'm really concerned, like, here's why, here's what I think, I would hope that, and I think they would listen to that. And if I said, I think this needs to be investigated by the state police. So normally they come in and investigate. But other than that, I don't have the power to make someone investigate the police. The prosecutor normally does that. They do a special request for that.
And I'm keeping you over, but this is the last question.
That's okay.
When is it appropriate? I don't know if the prosecutor requested or the attorney for the defendants requested, but when is, say, the need for a grand jury to come in, you know, convene a grand jury to go through whatever evidence they have, you know, to bring a particular charge against a person? Would that be when, say, a police officer is the defendant, or can it be just a regular citizen? We do know they use them for, you know, when a police officer has been charged. You know, they may bring in a grand jury to try to get some type of indictment, sending it to trial or whatever. But are those cases used for, say, any lay person, you know, convening a grand jury for a lay person as opposed to a police officer or a government official or what have you?
In Arkansas and in our circuit, we don't have that very often. But I mean, yeah, they could do a grand jury, I think, for anybody. I think typically that, but also the prosecutor has the authority to charge without a grand jury. And so normally they just make that decision. I think, especially in cases that involve.
Well, that's the reason for my question. If a prosecutor can just make the charge anyway, you know, I mean, why do we go through the grand jury process? You know, try to convene a grand jury. I mean, why do we do that?
Sorry, I'm going to cut you off. When I've seen it done, it was in cases that were either a close call, where the prosecutor felt like, you know, I don't know. I think we should just let the jury, a grand jury, decide, because I think it could go both ways. And so I don't want to, you know, affect this one way or the other. I don't know the answer. And so I'm going to let a grand jury pick. And then a lot of times with police officers, I mean, of course, the prosecutors would feel political pressure, you know, from law enforcement on one side, but then from everybody else on the other side. So if they chose to prosecute a police officer, if law enforcement's mad about that, they have to work with them every day. But then, so sometimes situations like that, I think, that are sensitive, I think they let those go to grand jury to say, look, it wasn't me one way or the other. It was, you know, the evidence, and the grand jury decided to do that. So that's my opinion about it. That's been my experience on it.
Mm-hmm. Well, I want to thank you again for coming on. I know the day has been long, and I really do appreciate you for coming on, speaking to us on this very important topic. We do know that someone, thanks for having her on your show, and it was very helpful. This is Mrs. Lakeisha Berry. That is one of the mothers that I've been advocating for past week or so or two, who had the daughters who were incarcerated down there, you know, in the city jail, never been in trouble to my knowledge. And they was given 30 days in jail. They're free now, but she went through a lot. And so hopefully, you know, she is pretty much has a peace of mind, you know, just hearing you. And so I thank you for that. And these are other people just saying thank you as well. And so we really do appreciate you. And I think you will agree with me when I say this here. that the best thing that when you run into these encounters, whether being charged or being a suspect, is not to say anything till you speak to an attorney.
That's right.
And I tell you
Hmm.
what really breaks my heart is that I go into these juvenile hearings sometime I have did in the past, and what that mom is, she's just worried about getting her child home, and so she pretty much will go ahead and allow her son to tell whatever, and they take that probation not knowing that there's conditions with that probation, and somewhere like weeks down the road or whatever, they mess up, and now they're incarcerated. And so please do, for the viewers that are listening, you know if you are arrested, do not say anything. Speak to your an attorney. Perhaps maybe you can give uh, this superior attorney, attorney Thompson, give her a call, and let her fight your battle, the professionals. And so, uh, attorney Thompson, I want to go ahead and give you the opportunity to close out uh, with whatever comments that you may have, and I want to thank you for coming on to testify. And just please know, you always got a base here to share information that it be legal or otherwise. So I extend this time to you now to close out.
Well, I was looking at my notes. I think we kind of covered everything, that could potentially happen, and things that could be implemented to help with some of these things. But I mean, I know that anytime anybody's arrested, or honestly, even if I've been stopped for a speeding ticket, you feel vulnerable. And to know that there's, I mean, officers, but and prosecutors too, that have so much power. I do think people worry that, they'll be wrongly, mistreated. And so I do think that there are some fail safes for watching for that. Judges watch for that. Defense lawyers watch for that. And of course, we have I do think most prosecutors, I mean, they're all, when they become prosecutors, they have to swear to uphold the Constitution, and they take an oath and to do that. And so I do believe that most of them do that. And then there is room for a few of them that don't do that, that there is misconduct, obviously, as we've talked about. And I hope that this conversation has eased some people's mind about, if that happened, there are some things that could be done about it.
Okay. And so there are some things that can be done, although it may be a uphill battle, climb or what
Sure.
have you, but
I think
there
that's
are
true.
options, what you're saying.
That's right.
Yeah.
Mhm.
Okay. Well, attorney Thompson, I really do. Again, I appreciate you for coming on, and someone like I done clicked on something there. Got to get that Brady rule off. But someone also want to thank you. I think they went ahead and thank you for coming on as well. Who was that? That was Mrs. Anderson, and matter of fact, a whole lot of them. They thank you for taking busy time out of your schedule coming on. Uh, Thanking you for sharing your professional discussions, if you will, for a better word. And so, again, please do stay in tune with Testify and keep watching.
I will. Thank you so
And,
much for having me. I appreciate
and
it.
tell your law partner, Attorney Holmes, hopefully he and I can do this sometime, bringing him on and, excuse me, and let me allow him to show his talent. Kind of lose my voice. But anyway, you have a remaining blessed day, okay?
You too. Thank you. Talk
All
to you
right.
later.
Bye-bye. Peace and love.
Mm.
Well, ladies and gentlemen, that concludes the broadcast. Hopefully, you did learn something today in terms of what is prosecutorial misconduct. You did learn the four things or the four ways of how it is prosecutor commit this, and I'll go back through them again, which Attorney Thompson, she went through them all. Uh, that very first one, for those of you who are tuning in, these are four ways that the prosecutor will commit misconduct. Failure to disclose exculpatory evidence. That word exculpatory evidence, basically what that's saying is that the prosecutor has information in his possession that he do not want the defendant and his attorney to be aware of. Okay, that is against the rules. Again, introducing false evidence. Sometimes it can be speech, not just introducing false evidence, but sometimes speech, using certain words that, that can really paint a picture that the defendant didn't even have a chance coming in to trial because, the deck was stacked against him. All right. Uh, Again, using improper arguments pretty much go in the same area as I mentioned with introducing false evidence. There are certain things that are considered to be improper in a court of law, as Attorney Thompson shared with us. And the last one, I think we all can associate with that based on what we have seen on TVs or television, or based on perhaps maybe you have been a victim or your family been a victim to where it was an unfair jury pool that was selected. This could be based on race. Sometimes it can be based on economics, what have you. But I think the one that we really identify with is how a jury pool is put together that may discriminate against the defendant. Okay. And so those are the 4 things that we talked about today. Again, exculpatory evidence is favorable to the defendant in a criminal trial that exonerates or tends to exonerate the defendant of guilt. Okay. And the other tool in that bucket, better way of explaining it, is the Brady Rule. The Brady Rule is where the prosecutor has a duty to disclose exculpatory evidence. Any evidence that the prosecutor have that may point, say, for example, to the innocence of the defendant, the prosecutor must turn or disclose that evidence to the other side. So that's all I have, ladies and gentlemen. I want to thank you all for sitting with me today. And hopefully, if I be in town, I'm going to come back with another show on Tuesday this coming week. Don't really know which one I'm going to do yet. But until then, as I always say, before I close out this show, I just want to say, may you all have a blessed remaining evening, if you will. And please, and I mean this when I say this, please do come back and join me this coming Tuesday. Hash this word about testify. This is your base, okay? If you can't tell it all in court, come here. I'll let you tell it on testify. Anything that's going on in the city, that you need to share, talk to me, and we'll check it out and we'll let you testify. Let you come testify. Okay, so until then, have a blessed remaining evening. Peace and love, and good night.